Today we are going to deal with chapter 7 of the Code of Criminal Procedure, which deals with the process of compelling the production of things which are necessary to be dealt with any investigation, trial, or any case for the purpose of inquiry. And according to chapter 7 of this code, the court may, as it deems fit, may compel the process of producing some things which are discussed under this head, which can be as summon, which is discussed in section 90 to 92 of the CRPC, and secondly a search warrant, which can be discussed between section 93 and 98 of the CRPC. Thirdly, the general provisions relating to search, which is under section 99 to 101, and other is miscellaneous, which are discussed between section 102 to 105. Now, according to the chapter 7 of this code, the court may compel to process to produce some things as firstly given in section 91. According to section 91, the court orders to produce summons or document or other thing. According to subsection 1 of section 91, whenever any court or any officer in charge of a police consider that the production of any document or other thing is necessary or desirable for the purpose of any investigation, inquiry, trial, or other proceeding under this code by or before such court or officer, such court may issue a summons and or officer with a written order to person in whose possession or power such document or thing is believed to be, requiring him to attend and produce it, or to produce it at the time and place stated in summon or order. Secondly, according to subsection 2 of section 91, any person required under this section merely to produce a document or other things shall be deemed to have complied with the requisition if he causes such document or thing to be produced instead of attending personally to produce the same. Thirdly, nothing in this section shall be deemed to affect section 123 and 124 of the Indian Evidence Act 1872 or the Banker Book Evidence Act 1891, or to apply to a letter, postcard, telegram, or other document to any parcel or thing in the custody of the postal or telegraph authority. Section 92, process as to letter and telegram. If any document, parcel or thing in the custody of postal or telegraph authority is, in the opinion of the district magistrate, the chief judicial magistrate, court of session or high court, wanted for the purpose of any investigation, inquiry, trial or other proceeding under this code, such magistrate or court may require the postal or telegraph authority, as the case may be, to deliver the document, parcel or thing to such person as the magistrate or court may direct. Subsection 2 of section 92, if any such document, parcel or thing is, in the opinion of any other magistrate, whether executive or judicial, or of any commissioner of police or district superintendent of police, wanted for any such purpose, he may require the postal or telegraph authority, as the case may be, to cause such search to be made for and to detain such document, parcel or thing, pending the order of a district magistrate, chief judicial magistrate or the court under subsection 1. Now we will be going to the second provision of the chapter 7, that is search warrant. According to section 93 of the CRPC Act, when search may be issued, the section 93 speaks about when a search may be issued. According to section 93 subsection 1 clause A, where any court has reason to believe that a person to whom a summon or order under section 91 or a requisition under subsection 1 of section 92 has been or might be addressed, will not or would not produce the document or thing as required by such summon or requisition. Or clause B, where such document or thing is not known to the court to be in the possession of. Clause C, where the court consider that the purpose of any inquiry, trial or other proceeding under this code will be served by a general search or inspection. It may issue a search warrant, and the person to whom such warrant is directed may search or inspect in accordance therewith, and the provision hereinafter contained. Subsection 2 of section 93, the court may, if it thinks fit, specify in the warrant the particular place or part thereof to which only the search warrant or inspection shall extend, and the person charged with the execution of such warrant shall then search or inspect only the place or part so specified. Subsection 3 of section 93, nothing contained in this section shall authorize any magistrate other than a district magistrate or chief judicial magistrate to grant a warrant to search for a document, parcel or other thing in the custody of the postal or telegraph authority. Now, section 94 deals with the search of a place Section 94 deals with the search of place suspected to contain stolen property, forged document, etc. If a district magistrate, sub-divisional magistrate or magistrate of first class, upon information and after such inquiry as he thinks fit, necessary, has reason to believe that any place is used for the deposit or sale of a stolen property, or for the deposit, sale or production of any objectionable article to which this section applies, or that any such objectionable article is deposited in any place, he may by warrant authorize any police officer above the rank of the constable to enter with such assistant as may be required at such place. Secondly, to search the name in the manner specified in warrant. Thirdly, to take possession in any property or article therein found which he reasonably suspect to be stolen property or objectionable article to which this section applies. Fourthly, to convey such property or article before a magistrate or to guard the same on the spot until the offender is taken before a magistrate, or otherwise dispose of it in some place of safety. Fifthly, to take into custody and carry before a magistrate every person found in such place who appears to have been privy to the deposit, sale or production of any such property or article, knowing or having reasonable cause to suspect it to be stolen property, or as the case may be, objectionable article to which this section applies. Subsection 2 of section 94 speaks about the objectionable article to which this section applies are: firstly, counterfeit coin; second, the piece of metal made in contravention of Metal Tokens Act 1989 or brought into India in contravention of any notification for the time being in force under Section 11 of Custom Act 1962. Thirdly, counterfeit currency note, counterfeit stamp, forged document, false seal, absence object referred to in section 292 of the Indian Penal Code. And seventhly, instrument or materials used for the production of any of the article mentioned in clause A to F of section 94. Now we are coming to section 95 of CRPC, which deals with the power to declare certain publication forfeited and issue such warrant for the same. Subsection 1 speak about the power to declare certain publication forfeited and to issue such warrant for the same, where a newspaper or a book or any document wherever printed appears to the state government to contain any matter the publication of which is punishable under section 124A or section 153A or section 153B or section 292 or section 293 or section 295A of the Indian Penal Code, the state government may by notification stating the ground of its opinion declare every copy of issue of the newspaper containing such matter and every copy of such book or other document to be forfeited to government, and thereupon any police officer may seize the same wherever found in India, and any magistrate may by warrant authorize any police officer not below the rank of sub-inspector to enter upon a search for the same in any premises where any copy of such issue or any such book or other document may be or may be reasonably suspected to be. Subsection 2 in this section and in section 96, a newspaper and a book have the same meaning as in the Press and Registration of Books Act 1867. Secondly, document include any painting, drawing or photograph or other visible representation. Subsection 3 of section 95. No order, pass or action taken under this section shall be called in question in any court otherwise than in accordance with the provisions of section 96. Now we are coming to our next section, which is section 96 of the CRPC Act, which deals with the application to High Court to set aside declaration for forfeiture. Subsection 1 of section 96 says that any person having any interest in any newspaper, book or other document in respect of which a declaration of forfeiture has been made under section 95 may within 2 months from the date of publication in the official gazette of such declaration apply to the High Court to set aside such declaration on the ground that the issue of newspaper or the book or other document in respect of which the declaration was made did not contain any such matter as is referred to in subsection 1 of section 95. Subsection 2 of section 96, every such application shall, where the High Court consists of 3 or more judges, be heard and determined by a special bench of the High Court composed of 3 judges, and where the High Court consists of less than 3 judges, such special bench shall be composed of all the judges of that High Court. Subsection 3 speaks about on the hearing of any such application with reference to any newspaper, and any copy of such newspaper may be given in evidence in add to the proof of the nature of tendency of the words, sign or visible representation contained in such newspaper, in respect of which the declaration of forfeiture was made. The High Court, subsection 4, says that the High Court shall, if it is not satisfied that the issue of the newspaper or the book or the other document in respect of which the application has been made contained in any such as is referred to in subsection 1 of section 95, set aside the declaration of forfeiture. Subsection 5 of section 96 speaks about where there is a difference of opinion among the judges from forming the special bench, the decision shall be in accordance with the opinion of the majority of those judges. Now, here it is been discussed that the application to High Court to set aside declaration of forfeiture, how to be dealt with, and now we are going to our next section, which is section 97, which deals with the search of a person wrongfully confined. So, according to section 97, if any district magistrate or sub-divisional magistrate or a magistrate of the first class has reason to believe that any person is confined under such circumstances that the confinement amounts to an offence, he may issue a search warrant, and the person to whom such warrant is directed may search for the person so confined, and such search shall be made in accordance therewith, and the person, if found, shall be immediately taken before a magistrate, who shall make such order as in the circumstances of case seems proper. So here it's defined that if any person is wrongfully confined, the magistrate or the subdivisional magistrate or the magistrate of first class may, if he thinks that the person is confined wrongfully, and then he can issue a search warrant for the person to whom such a warrant has been directed, and may for search of that person so confined, they can be immediately taken before magistrate, who shall make such order as in the circumstances of the case he seems proper. So now we are moving to our next section, which is section 98, which deals with the power to compel restoration and abduction females. So according to so now we are moving to our next section, section 98, which deals with the power to compel the restoration of abducted female. So according to section 98 of the CRPC Act, upon complaint made on oath of the abduction or unlawful detention of a woman or a female child under the age of 18 years for any lawful purpose, a district magistrate or a subdivisional magistrate or a magistrate of first class may make an order for the immediate restoration of such to her liberty or of such female child to her husband, parent, guardian, or other person having the lawful charge of such child, and may compel compliance with such order using such force as may be necessary. Now we are moving to our third category of chapter 7, which is coming into the process of compel to the production of thing, and this third category is the general provision relating to search. So according to this, section 90 of CRPC Act deals with the direction etc. of search warrant. According to section 9 of this the provision, thus section 38, 70, 72, 74, 77, 78 and 79 shall so far as may be apply all search warrant issued under section 93, section 94, section 95 or section 97. So now we are moving to our next section, which is section 100, that deals with person in charge of closed place so to allow search. Repeating. Person in charge of closed place to allow search. According to subsection 1 of section 100, whenever any place liable to search or inspection under this chapter is closed, any person residing in or being in charge of such place shall, on demand of officer or other person executing the warrant and on production of the warrant, allow him free ingress thereto and afford all reasonable facility of a search therein. Subsection 2 of section 100 speaks about if ingress into such place cannot be so obtained, the officer or other person executing the warrant may proceed in the manner provided by subsection 2 of section 47. So according to subsection 3 of section 100, where any person in or about such place is reasonably suspected of concealing about his person any article for which person is a woman, the search shall be made by another woman with strict regard to decency. According to subsection 4 of section 100. Before making a search under this chapter, the officer or other person about to make it shall call upon two or more independent and respectable inhabitants of the locality in which the place to be searched is situated, or if any other locality, if no such inhabitant of the said locality is available or is willing to be a witness to the search, to attend and witness the search and may issue an order in writing to them or any of them so to do. Now, according to subsection 5, the search shall be made in presence, and a list of all things seized in the course of such search and of the place in which they are respectively found shall be prepared by such officer or other person and signed by such witnesses, but no person witnessing a search under this section shall be required to attend the court as a witness of the search unless especially summoned by it. According to subsection 6 of the section 100, the occupant of the place search or some person in this behalf shall in every instance be permitted to attend during the search, and a copy of the list prepared under this section signed by the said witness shall be delivered to such occupant or person when any person is searched under subsection 3. A list of all things taken possession of shall be prepared, and a copy thereof shall be delivered to such person. Subsection 8 of section 100. Any person who without reasonable cause refuses or neglect to attend and witness a search under this section, when called upon to do so by an order in writing delivered or tendered to him, shall be deemed to have committed an offence under section 187 of the Indian Penal Code.